What happens, Jessica, if a client dies before their divorce is final?
So if they do not have a written estate plan, then there are, the usual intestacy options, and those are options that occur according to law. We've talked about them in past episodes. But just briefly, jointly held assets such as a jointly held bank account automatically belongs to the other co-owner. Community property assets would then belong to your surviving spouse. Separate property assets would belong partly to your spouse and partly to your children or other family members. And then without a written estate plan, there may need to be some court involvement, either a spousal property petition or a probate, or sometimes both.
Right. Okay. So it's intestacy is intestacy. It's always bad and complicated.
Mm-hmm.
And in the case of a pending divorce, you still have the intestacy problems, but you also have the fact that your spouse, who you're trying to get divorced from, is probably going to inherit a lot of stuff. Okay, so what about if there is a written estate plan?
If there is a written estate plan, that is still valid and that will still be followed. And, again, typically the plan leaves everything to your spouse. Again, if you're going through a divorce, that is most likely not what you want to happen.
Okay, so the bottom line here, you are married until a judge says you're not married. And that applies in the world of estate planning or lack thereof. And so whatever you've got when on the day you file for a divorce is what is going to happen unless something else happens. So just want to say that's not great, but all is not lost.